So without further ado, my pleasure to welcome Glenda. So Glenda Graham is a partner at Norris Ward in Hamilton, and she works in the field of succession planning and wealth protection. So Glenda's been practicing around 18 years, would that be right? Yep, so she has a huge amount of knowledge and expertise, and we're really excited to have her back. So it would have been about 3 years ago that she started, she came over and did a presentation with us and went through what was sort of happening at the time, was like the start of the changes. And that was really useful. We know everybody got a lot out of that. So really excited to have you back for a second time. Thank you, Glenda. We look forward to learning lots today. So I'll hand it over.
Thank you. Thank you. Well, I'm very mic'd up, as you can see. I've got bits all over me. I feel like I should be on the Secret Service, but nonetheless. So, thank you for having me. It feels very nice to return. I never knew this theatre was here, so it's been quite a revelation today. So, let's start off. Hold on, got to do the clicky thing. There you go. Right. Let's start off with trust and a question to you. Who actually has a trust sitting in this room? Is that going to be pretty much, oh, look at that. Okay. Do any of you remember why you have a trust? And I know that sounds a slightly tongue-in-cheek question, but you'd be surprised how many people have no idea why they've got a trust. They just have a trust. There were less hands that time. Let's see again. How many people remember why they've got... Yeah, no, there was a sizable downplay in the hands. So I suppose if you can remember why you formed your trust, can anyone actually put that explanation into words, or is it more of just a vague feeling? Vague feeling or words? Words? Proper words? Vague feeling? Oh, okay, right. There you go. Well, it's always nice to sort of gauge where people's knowledge and theory is about why they have what they have, but historically, as you know, trusts were very, very common. And just about everyone had one, it seemed. You know, you had one because Mrs. Jones down the road had one, and that seemed like a good idea at the time. And to be fair, there were some good reasons for having a trust. But these days, time's gone on, legislation, laws and government policies diluted some of the reasons for having a trust. And for some of you, the reason why you had it in the first place is probably up and disappeared at this point. So historically, why people may have had a trust, there's a few reasons, but we'll talk about some of those. Firstly, creditor protection, what I would put into the umbrella of creditor protection. So if you owned your own home, you wanted to protect it from a potential failure of a business venture, then you'd put the home into the trust, and that would give you protection from creditors coming to attack you. You might have also had a trust because you wanted to put assets into it so that you didn't have assets in your estate which people could come and claim against. So if you put your assets from your personal name into a trust during your lifetime, then those assets no longer form part of your estate, and then when you die, people can't, disgruntled family members can't come and attack your will because there isn't much to attack because everything's in a trust. As a third heading, lots of people formed trusts for charitable purposes or protection of vulnerable people. So, for example, if people had children who were intellectually not so well or physically disabled, or someone who had a drug or alcohol dependency, or just purely someone who was hopeless with money, and so the thought of them inheriting a whole bunch of it wasn't so good, trusts were quite, and can be still quite common. A charitable trust would often be formed for people who wanted to do good deeds and to support causes that they believed in. The last heading really for forming a trust was relationship property. So they were used for the purpose of reducing the chance that somebody, a partner, would come and attack your assets or assets you'd brought into the relationship. So with all that in mind, some of you might now have remembered why you had a trust. In 2021 though, so the new Act comes into force at the end of January, 30th of January 2021. So what might be the reasons for keeping a trust in 2021 or setting up a trust? So I ask this question of my clients a lot. I don't get a lot of answers, but it's always a good place to start. The purpose of a trust is to protect against risk. So therefore, you need to be able to identify your risk and gauge how likely that risk is going to occur. So when you think about your own trust, can you identify the risk that you are trying to protect from? And I do get a lot of blank stares, but eventually we do work out what that is. So, for example, in this day and age, if you are a wage or a salary earner, you've been married for a number of years, you own your own home, it has a mortgage to the bank, and there's no real special circumstances in your immediate family that you need to think about, then it is highly likely that you do not need a trust, and that the costs of forming one and the management of it is going to far outweigh the risks that you are faced with. Now, I know that probably sounds like I'm going to do myself out of work here, but to be honest, if you fall into that camp, the likelihood of you needing a trust is pretty low. You will, however, need a good estate plan. So you will need a good will and you will need some enduring powers of attorney, but you probably don't need the trust. On the other hand, if you own your own business and you employ some staff, then a trust to ring fence your assets like the house you live in would be a really good idea. And that reason still exists from historic times to now. Creditor protection is still a valid reason to have a trust. You do have to make sure that the trust is formed before there's any insolvency concerns though, because if you form a trust once those issues have arisen, then it's quite likely the official assignee would just sweep the trust aside. But if you get your timing right, creditor protection, still a very good valid reason to have a trust. If you fall into the camp of single and wealthy, then a trust with a prenup, officially known in lawyer terms as a contracting out agreement, is still a good reason to have a trust. You can't, as lawyers, we wouldn't say confidently now that having a trust formed before a relationship would mean that it's immune from partners and spouses attacking it, but a trust with a prenup is most likely going to be your best form of protection in terms of separation or death. There's a caveat to that, however, which is that you must be diligent once you have the trust to ensure that you don't mix up what are relationship property assets with trust assets, because you will likely erode the protection of the trust that you've tried to create. So if we apply that for a minute, we're going to have fictional Bob and Sue. So Bob and Sue have been in a de facto relationship for 4.5 years. Bob had a trust prior to the relationship, and the trust owns a rental house. The rent from the trust has been paid into Bob and Sue's joint bank account, and it's been used by them for paying the mortgage payments on the property that they live in together, the groceries and the utility bills, and several overseas holidays. So in that case, Bob probably thought he was doing pretty good because he had a trust before he got into the relationship, so that should stay his separate property. The issue, however, is that the rent from the trust has been used for relationship purposes, so the groceries, the phone bill, the overseas holidays. So it's highly unlikely that the trust would still be Bob's separate property if him and Sue separate. So Sue may very well end up with a half share of the equity in the rental property, irrespective of the fact that Bob came into the relationship with the trust. Had Bob had a little bit of nous and probably a bit of advice though, what he would have done was put the income into a separate trust bank account and use that only for his purposes or for the purposes of the trust. That may have kept the trust safe and sound, but even better if Bob had actually had a contracting out agreement the trust would still likely be his, even if he had gone on to use some of that income for relationship purposes. So the fact of having an agreement which says this is mine and this is yours, and the trust on his side is his, is the kicker. In terms of the last reason really to have a trust in 2021, if you still have vulnerable family members and you want to make sure that either to protect them or to keep assets out of your estate, a trust will still work. The one reason that I would tell you that the trust will not work in this day and age is for the purposes of getting a residential care subsidy. So that's getting a subsidy to pay for your care costs in old age. The ministry are stringent on their view that trusts in general are a deprivation of assets. And so they say that but for the trust, you would have had access to assets to pay for your care. So they do not particularly like trusts, and they've found lots of ways to get under the skin. And generally that is done on the basis that you will have done gifting, and a lot of you in this room who've had a trust would have had gifting programs where you would have been giving $27,000 a year to the trust and gifting off each and gifting off that debt. The ministry's view of the world is that it is not 54,000 that is permissible, it is only 27,000. So only one of your, if you were both gifting, only one of your gifting is allowable. And what they do with the other 27,000 is they write that back into your asset column. And so at the end of the day, they calculate what your assets are, and you either fall under the threshold or you're over it. If you are over it, you are on your own and you pay for your care. If you are under it, you will get a residential care subsidy. So for the purposes of purely forming a trust for residential care subsidy eligibility, those days are gone. And for anyone who had a trust based solely on that and you can't identify with any of the other reasons I've spoken about, probably now would be a good time to be looking at why you've got it. So from what I've said, you will have worked out that having a trust or not having a trust is horses for courses really, and needs careful consideration of what risks you're trying to protect yourself from and what benefit the trust is going to bring you. Because there are certainly some cons in having a trust, and these cons are probably going to, with the new legislation, come into stark recognition for a lot of you. In order for a trust to be fit for purpose, there is going to need to be ongoing management and record keeping. And trusts can become complicated when you also have companies in the mix, or if your trust is trading, so it's making income. Not everyone is cut out for the degree of administration that's required to keep a trust going. And for a lot of clients, when I explain what a trust is and the fact that you have now put assets into the trust and you have parted with possession of those assets, the implications of that are all a little daunting. So you don't own the property that went into the trust in your own right anymore. You can't make the decisions of an owner. You can't decide that you're unilaterally going to sell the thing and take the money and, well, if we could get out of New Zealand, run away to America. And you can't take into account only your own wishes and desires. So if a property is in the trust, then you have to make decisions as a trustee which are for the benefit of all of the beneficiaries. You've got to consider who all those people are, and you must act in accordance with the trust deed. And for a lot of people who are used to having their own property and doing what they like, putting it into a trust is quite the, really. So if you can't identify with reasons, and it sounds horrible not having control, a trust probably isn't for you either. So let's carry on our way. Okay, so the Trust Act, as I said, comes into force at the end of January, 30th of January 2021. And it was a very long process to get to the Act, which is why I was here 3 years ago talking about trust, talking about the Act. So we've had a year's, by the time it comes into force, we will have had about a year's lead-in time. And it's been said that the objectives of the new Act is quite a few things, but as a summary, to clarify for trustees what your obligations are, give better guidance to beneficiaries about trusts and what they're entitled to from the trustees. You'll like this one. Make trust law more useful and accessible to the general public. So they'd quite like you to be able to read the legislation and understand it. And there were undoubtedly some practical and administrative problems with the Act. I mean, the existing Act is 1956, and things have changed a little bit since 1956. In particular, well, one of the very obvious administrative problems is, in this day and age, lots of trustees become mentally incapable. It was very hard to, whilst it's not necessarily hard to remove those trustees from being trustees, it was very hard to take them off the title, the land title. And that is, at present, involves a rather complicated application to the High Court for what's called a vesting order. It's expensive, it's a waste of time, and the new Act tries to fix some of those slightly irksome problems. So, in terms of what those principles have meant for key changes that are coming our way as trustees, they are the following. Like I say, overall, a higher degree of accountability and administration. That's really the thrust of the entire Act. But if we're going to pick out some things that are going to affect you the most, they will probably be these three things. We now will have what are known as mandatory and default trustees' duties. And the whole purpose of having those is to make sure that trustees understand what they must do. The second change will be requirements for how trust information is managed. So how it's stored, who has copies of what, and why. And the third one, which, to be fair, there's probably been the most press about entirely, is the requirements for disclosing trust information to beneficiaries. And that one is the one that strikes fear into the heart of most trustees. And we've had many a conversation about why telling the beneficiaries might be a good idea. One point that it really is important to notice, because you'll be sitting there thinking, oh, well, it's only those lawyer trustees or those accountant trustees that need to worry about this stuff, surely. Sorry to say, everyone who is a trustee is going to be caught by this legislation. It doesn't matter whether you're a Norris Ward trustee or you're just a mum and dad trustee. Your trust is in this legislation, and your job as trustees is mandated by this legislation. And if you only really walk away from one thing today, I think it needs to be that the Act is a pretty clear cue that there's going to be a much higher degree of accountability and responsibility expected and demanded of trustees. So if you only take away one thing, that is it. The world has changed. Beneficiaries will be able to be better informed because they will go to the legislation, and it's reasonably worded that your average beneficiary will work out what it says. In historical times, if you were a beneficiary of the trust, you really needed to read a whole lot of cases before you quite understood how things were working, and that was beyond a lot of beneficiaries. But this Act's pretty helpful. It sets things out in reasonably clear language, and it seems to me that it's more likely because of that beneficiaries will have some inkling of what their rights are, and they'll probably be more willing to pursue trustees who don't measure up. And as a trustee, that should probably strike fear into your heart as well. It only takes one aggrieved beneficiary armed with one litigious lawyer, and trustees will find themselves in a world of pain. And there are litigious beneficiaries, and there are suitably minded litigious lawyers. So I suspect that it won't be long before we have our first case under the new Act. So as a starting point, what do you do as a trustee? Question, how many of you have ever actually read the trust deed, your trust deed, properly, like all the words, not just, a few? Yeah? Again, less hands than the first time when I said who had a trust. So the first step is find your trust deed, and I know that can be a challenge too, but try and find it and read it and try and understand what it says. And if you don't understand what it says, go and ask someone. The trust deed is the thing that says what you are allowed to do as a trustee. If you do not act in accordance with your trust deed, then you are in breach of trust and you might be sued by a beneficiary or you might be sued by a third party. But it's a bit like a company constitution, right? The company constitution governs how the company runs, the trust deed governs how the trust runs. So let's ask some questions about, so the people that read the trust deed, I know this is a limited audience, but the people that actually read the trust deed, how many of you know whether you need a unanimous decision of the trustees to do anything or whether you just need a majority? Yes, this woman's very good. She keeps putting up her hat. Good. I would wager probably that 90% of your trustees will say it's a unanimous decision of the trustees to do anything. But there are the odd few that talk about a majority. Okay, next one. Do you know who holds the power to hire and fire trustees? Or beneficiaries? Oh, yes, we've got another candidate who knows things. That's good. Is it the trustees or is it the people who set up the trust, commonly called the settlors? Yes, righty-ho. So that's really important because if you want to get rid of some beneficiaries, it probably makes sense to know who can do it, right? And we see trust deeds that say it's the trustees. Often they'll say with the consent of the people who set up the trust, but sometimes it'll purely just be the trustees. And sometimes it will be the settlors. Okay, next one. This is a more tricky one. Do you know whether you as a trustee are allowed to act for your own benefit when you deal to the trust fund? Are you allowed to do things that benefit you even though you're a trustee? See, right, at that point we lost everyone. Right. So, your job as a trustee is to act for the benefit of the beneficiaries. And if you are a trustee and a beneficiary, that might end you up in a bit of conflict. So you need to make sure that you can make decisions as a trustee which you are also going to benefit from. Okay. Do you know how long the life of your trust is? And do you know, oh, there you go, got some mums on that one. Do you know whether it can be shortened up? Can it? So most of you are probably sitting there thinking, now that is easy, I know it's 80 years. I read 80 years somewhere, it must be 80 years. You're generally right that most of the trust deeds at the moment will talk about the life of the trust being 80 years. But there is often a provision in there which says that the trustees can decide to bring that date forward. Now there's a few parameters around that, but generally speaking most trust deeds will have that. I have, however, seen a lot of trust deeds that have shorter than 80 years. Some of them might say 40 years. And I have been in a situation, it wasn't our trust deed, but I've been in a situation where it was 40 years. 40 years came and went, and none of the trustees realised that the trust had ended. And that was a significant problem because the trust held several farms. The trust deed said when the trust ended, the assets went to the children. Mum and Dad weren't keen about all that stuff going to the children, funnily enough. So, you know, if you don't know when the trust is meant to end and you start holding, it goes by, those trustees were actually, post the 40 years, holding those assets for their children. And what we had to go through was a complicated process of the children agreeing to gift them back to the parents, who were abhorred that they didn't actually own anything anymore. So, that they just, you know, the farm that they live and work on and all the other farms weren't things that they actually had control of in any shape or form. And thank goodness they had very obliging children, so it was fine. But if you don't have obliging children, it may not be quite so fine. So you must work out what the life of the trust is. And I suppose I have a number of people I've come across in the last 18 years, and they sit there and they say to me, oh, but my trust deed's just standard. It's a standard old trust deed. There is no such thing. I promise. There is no such thing. No two trust deeds are alike, and we see them every day, and you look at them and you go, oh, that doesn't work quite so well, because they're just, whether it's an accountant that set them up, a lawyer that set them up. Lawyers don't have standard trust deeds. We don't go to a place in the sky and we all get the same trust deed. Everybody has their own precedents. So you must read it, you must understand it, and if you become a trustee and you've never read the trust deed, then look out, because that's going to be a problem. The other point that I often spend a lot of time talking about is what's my trust and what's me? And aren't they just all the same thing anyway? Not quite. Not quite. So if you're going to have a trust and you've got your personal stuff, then you need to be looking at all of this reasonably regularly, because it needs to all work in harmony together. It's not a case that your trust's going to operate over here and your personal stuff's going to operate over here and never the two will meet. Because if you don't keep up with reviewing your trust and your personal stuff, it can be a bit of a disaster. The whole reason that you set up the trust in terms of protecting from risk, if you don't manage the thing properly, the trust might just get swept aside, and all those advantages in terms of protecting you from creditors are not going to be there anymore. If you don't form a trust with the intention to not have possession of those assets anymore, then what will likely happen if the trust is busted is the assets will go back into the personal name. And if you are the IRD, you would quite like that, because that means you can get access to them. So if you're going to have a trust, run it properly, because if you don't, it will get busted anyway, in which case you don't have the protection anymore. And then you know, the IRD or the creditors or whoever will have something to attack. And it's a bit the same on the relationship property front. A disgruntled de facto partner or a spouse, you may not end up owning what you thought you owned. So if we talk about what a trust is, because I think that's relatively unknown, a trust is a structure whereby the trustees will, in accordance with the terms of the trust deed, hold the property for the benefit of beneficiaries, and the trustees are accountable to those beneficiaries in terms of what they do with the trust property. So that, I suppose, concept, when I keep talking about parting with possession of assets, that's why, because you're now holding them for the benefit of beneficiaries, not for your own benefit. So your sole job as trustees is to consider what are the best interests of the beneficiaries and apply the trust fund accordingly. And all of you are probably sitting there going, well, I am a beneficiary, so what's the problem? I'm a beneficiary of my own trust, what does it matter? The likelihood is you are one of the beneficiaries, or two of the beneficiaries, but there will be a whole slew of other people, your kids, your grandkids. You might even be surprised to find that the spouse of your daughter is a beneficiary. There will be a whole slew of people in there. So your job as trustees is not to sit there and think what's best for me and what's best for my children. Your job is to sit there and think what's best for all the beneficiaries of the trust and actually know who they are. And when I talk about separation between trust and personal affairs, that's because the assets that are in the trust are no longer yours. So they are not going to be dealt with in your will. And I cannot count the amount of times I've had meetings where clients start talking about assets as if they owned them and talking about what they wanted to happen to them in their will, for me to say, well, actually that's nothing to do with your will because you don't actually own it, the trust does. So after you die, the trust is going to carry on. You can't bind the trustees to doing what you want them to do with the assets, and your will only cover what you actually own. And it sounds really trite, I suppose, to a certain extent to say that, but that's often not understood. Your will is for what you own in your personal name. Your trust will carry on. It will carry on with the assets, and those assets don't suddenly tip back into your estate when you die. Right. Okay, so who's who in the zoo? Because for anyone who has read their trust deed, you will have seen that there's a whole slew of people in there that are mentioned, and some people feature in every single role all at once. So often what we talk about is a discretionary trust. And a lot of you won't know you have discretionary trusts, but most trusts in New Zealand are discretionary trusts. So it's discretionary because the trustees have the power to determine which of the beneficiaries are going to benefit from the trust, how and when those beneficiaries are going to receive that benefit, and what share they're going to receive. So for your most family trusts in New Zealand, that will be what you have, a discretionary trust. I said before about a settlor. So a settlor is somebody who has formed the trust. They're generally the people who placed assets into the trust in the first place. And normally, because they have put the assets in, they tend to end up with powers under the trust deed. And those powers will generally be powers to appoint and remove trustees and or beneficiaries. So a lot of times trust deeds will talk about the settlors have settled $10 onto the trust. You will see that in the background preamble stuff. That's why, because it's that settlement of putting that first lot of assets into the trust. Trustees are people who hold and control the trust property for the beneficiaries of the trust. So you don't see the Smith Family Trust on the land title, you see the names of the trustees on the land title, and that's why. The trustees are the ones that hold the trust property. Beneficiaries are the people or the entities, because sometimes beneficiaries of a trust might be a company or they might be another trust, are the ones who are intended to benefit from the capital and the income of the trust. And again, it goes back to the concept of discretionary beneficiaries. So those are the people that can only benefit at the trustee's discretion. And at law, we talk about that as being a mere hope of benefiting from the trust fund. Those people versus the final beneficiaries. The final beneficiaries are the people who take the pot of gold, if you like. They are the people who get the money or whatever, the property, when the trust fund ends. And for a lot of you, those people will be your children. The list of discretionary beneficiaries, however, may be quite long, and they may include all sorts of people. And I can tell you now that when we're talking to clients at the moment, they're quite surprised about who else is in that very long list. And it's become a bit of sport to see how wide the list might be. I think we had one the other day where it said anyone who was a relative of the settlors. So that's quite wide. It will take a while to work through. They had no idea, by the way, so that was quite interesting. Okay, so there are just a couple of little things that the new Act's bringing, which, whilst not biggies, are probably good to know. I said before, a lot of your trust deeds will say the life of the trust is 80 years. The new Act means that you can now have a trust that will have a life of 125 years. So that sounds quite a while, doesn't it? So the pool of beneficiaries consequently is likely to be quite wide, because you might find it's mum and dad and the children, but now it's the grandchildren and maybe beyond that. So for those of you that have existing trustees, when the Act comes in at the end of January, the life of the trust doesn't automatically get extended. So it's not going to be 125 years automatically. If your trustee says you could vary it, then you may be able to vary the trust deed for it now to become 125 years, but unless you have that power of variation, then your existing trust deeds will stay 80 years. But for new trusts that are formed after 30 January 2021, then they can last for 125 years. The other minor change, but again reasonably important, at the moment there's a thing called an age of majority. The age of majority is 20. And so for the moment you can't be a trustee and you can't inherit until you get to that age. It's going to move to 18, which means someone can be a trustee at age 18. It also means you will be able to inherit under a will at age 18. So thought those seemed a bit more important to mention. Okay, so I keep talking a lot about administration and processes are going to be important in the new Act. And this is really to protect trustees from scrutiny of their actions. And whether that's going to be beneficiaries or whether that's going to be third parties, the standard of administration of a trust is going to have to increase. Out of curiosity, how many of you at the moment have a meeting of trustees? Every year, say. Yep. How many of you record any minutes from the meeting? Oh, how many of you have an agenda when you go into that meeting? Yeah, not bad, not bad. Okay, so I would say to you that the first thing that you must do under the new Act is have an annual general meeting. Should have all the trustees there, and it should have an agenda which you've determined ahead of time. I would suggest that you should have the trust's accountant along, you should have the lawyer there, and at least for part of it, if you're a trust that has investments with Craigs or whoever, then you should have the investment advisor along as well. So what kind of stuff are you going to talk about? I think that if you are a trust that owns a residential property, and just that, then you might be going to talk about the basis on which mum and dad, who are generally in the property, get to carry on living there. So that might be because they're going to pay the rates or whatever. That the property is correctly insured in the names of the trustees, because what I commonly find is the property is actually insured in mum and dad's personal names, which doesn't work if it's in the name or if it's actually owned by the trust. Whether there's been any improvements to the property and how they were paid for. So a lot of clients will say, oh yeah, we renovated the kitchen last year, it cost us 20 grand. And I'll say, yeah, where did that 20 grand come from? Oh, we paid for it. Yep, but you paid for a kitchen in the trust property, so you need to really gift that money across to the trust, because at the end of the day the trust is the one with an improved kitchen, which presumably will lead to a better sale price. So a lot of people forget that if they are the ones in the house, then, and they're putting money into the trust to fund whatever, mortgage payments, kitchens, that you actually do need to tidy that away in terms of gifting. You might talk about maintenance. Does it need a new roof? When might it need a new roof? And you'll probably, and definitely should, talk about the beneficiaries. So what's their circumstances? Is, I don't know, the kid had a third child, or has there become an addiction issue? What's happened? Because you need to know as trustees what the circumstances of your beneficiaries are, because they're the people that you're meant to be thinking about the whole time. And for some of you, if you've got a gifting program running, then whether there's any further gifting due. And I know for many of you, you would have been gifting quite regularly up until about 2011, 2010, when the gifting laws changed and gift duty was abolished, and there are still people who stopped gifting. There's still debt owed to them by the trust, and that hasn't been taken care of. So the abolition of gift duty didn't actually take care of everybody's little gift programs that they were doing. So if you're in that camp, that also would need addressing. So if you're an income earning trust, so as opposed to just one that owns a house, then in addition to everything I just said above, you might be thinking about whether the GST and liabilities are up to date. You'd be looking at the financial accounts for the trust. You'd be thinking about distribution of income to beneficiaries, and you'd be seeing whether the investment strategy of the trust was suitable and it was still appropriate. If it is a trading trust, you do need to satisfy yourself that the IRD side is up to date, because there is no, the IRD won't hesitate to force that on you personally if it isn't. So you need to make sure you've ticked that one off. You should take some minutes, because at the end of the day, if you want to be able to prove that you have thought about all the beneficiaries, then the minutes are the best way to do that. There will be a trustees resolution, hopefully, you should have one. That should be signed by all the trustees, and then it should go into the trust's minute book. Now, at that point, maybe everyone's a bit blank about what the trust minute book is, but I swear to you there will be one somewhere. There'll be either the accountant or the lawyer will probably hold it, but it should have all of the trustees' resolutions that you have ever made, and it should be accessible for trustees so that you can go back and say, well, yes, dear judge, we did think about and look at all of this. If you get the investment advisor along, and I like I say, would recommend that one, the investment advisor could give you advice on how the portfolio is tracking. They will likely talk about what shares should go and what shares should stay, and they will also talk about the balance of the portfolio. So you often have the case where a trust portfolio might start out quite conservative and be geared towards income. For the settlers generally, but over time it may actually be appropriate to be in a growth portfolio. So one of the things that we quite like the investment advisors to talk about is whether the balance of the portfolio is correct. Having the trust accountant and the lawyer in the same room at the same time, hearing the same information, both putting in the expertise is really helpful. We have found that to be really helpful, and I have had clients who have been quite sceptical about why that would be beneficial, only then at the end of the meeting to turn around and say to me, well, that was absolutely worth it, because A, I don't have to repeat everything I just said to the other one who didn't hear it because they were in the room, and secondly, we were all able to work in conjunction with each other. And often the information that an accountant might be looking for will be different to the information that a lawyer might be looking for, and things will have different significance to each profession. So having everybody, same room, you can say whatever you like, but both sets of ears hear it, has been really useful. The kicker, obviously, to all of that is that if you have a professional trustee, then their services are going to come at a cost. And a professional trustee who's doing their job properly is going to expect to be paid for doing that, given the risk that the trustee takes on. So there isn't, in my experience, one fee fits all. Not all lawyers charge the same fee, and neither do accountants for that matter. So it's going to depend on what assets are in the trust and what administration's required. For example, I am a trustee of a trust where we have an investment portfolio. We've got another trustee with me. They are not, beneficiaries are not people in any way related to me or the other trustee, and we have the accountant involved and the investment advisor. And the cost for that will be different to mum and dad and, say, Norris Ward acting as a professional trustee. So it is horses for courses in finding out what that ongoing cost of administration is going to be when you form the trust is definitely worthwhile. Right, so I said before that there were 3 specific areas where the new Act's really going to make changes. And the first of those was that it was duties of trustees. So we'll talk about those for a minute. What the Act does is set up duties known as mandatory duties and default duties. And the idea is that if we put them in the legislation, trustees will know what they have to do. That may be optimistic, but that's what the lawmakers say. The first one, the mandatory duties. So these are the ones that the trustees have to do. They can't be modified, they can't be excluded by the trustee. So they highlight the things I've been talking about in terms of knowing what the terms of the trust are, acting in accordance with it, act for the benefit of the beneficiaries. So all those fundamental, if you like, trust concepts are pretty much encapsulated in those mandatory duties. The second side is a little more interesting. So those are the default duties, and they are also going to apply unless the trustee modifies them or excludes them. So for a lot of trustees, those are modified. For example, duty to act unanimously, that may be modified in the trust deed. If the trust deed says trustees can act on a majority, then the duty to act unanimously has been modified. A lot of times the duty not to exercise power for your own benefit, that's often modified as well, because, as I said before, trustees often want to do things that benefit them. So what trustees should be doing, and to be fair, if you're a layperson trustee, you're going to need help with this one. You should be looking at the trust deed and seeing whether there's any provisions in there that conflict with any of those duties. And if there are, then it might be a good time to consider whether the trust deed needs varying or modifying so that it does tie in nicely. That involves really finding the clauses in the trust deed which will modify the default duties, because there will be some, and then deciding whether that the trust deed is explicit in that modification and that's okay, or whether it's a bit wishy-washy and maybe we should do a variation to make it clear that we're not going to comply with the duty to invest prudently. What we have found on a whole is that most trust deeds don't have suitable investment provisions in light of that duty to invest prudently. They don't often have enough wording to negate the duty to avoid a conflict of interest or acting for one's own benefit. So those to us, out of that list of default duties, are generally the 3 that the trust deeds aren't quite stacking up in. So if you have a trust that has a portfolio at Craig's, that duty to invest prudently is going to be important. If you have a trust fund where all you do is shove it in term deposits earning crappy interest rates right now, that might be a problem and will conflict with your duty to invest prudently. But if you want to do that, as trustees, if you've decided that no, irrespective of the interest rate, that's how we're investing our trust fund, then you're going to need to make sure that your trust deed is clear that the duty to invest prudently is negated, because no prudent trustee right now should probably be having all their assets in the term deposit basket, given that I think I saw at the bank this morning it's 1.5%. Okay, so the second part was information, in terms of changes, was information for trustees to keep. So this is known as core documents. The Act says the terminology is core documents. So these are rules about what trustees have to hold, how many of you have to hold that information, and for how long. The good news is the provisions are drafted in a way that it doesn't require you to hold a physical copy, so you can have an electronic copy of things if you want to. Every trustee, whether your mum, dad, Norris Ward McKinnon, has to hold a copy of the trust deed and any variations made to it. So for all of you sitting out there who have no idea where your trust deed is, it's time to find it. If you can't find your trust deed in its original signed form, but you have a copy, and you're sure that the copy is as per the original, then it would be a really good time now to pass a trustee's resolution which confirms that the copy is a true copy of the original to the best of the trustee's knowledge and belief. Because what you will find is that the banks and anyone else who is doing anti-money laundering requirements on trusts will be asking for your trust deed, which is an entirely large pain in the butt if you can't find it. So if you can't find it but you have the resolution with a copy, that will probably keep the banks or anyone else for that matter happy from the anti-money laundering point of view. Everything else on the wagon wheel, the smaller spokes there, the requirement is that one trustee needs to hold that stuff. And if you start thinking about what that stuff is, it's quite a lot of stuff. For example, any written contracts, so that's going to be all agreements for sale and purchase that you as trustees have signed. Decisions that you have, stuff that you've signed with Craig's or Forsyth Bar, anything along those lines. Any records of trustees' decisions that you've made, so trustees' resolutions. Some form of knowing what all the assets are, and if you're not a trust that produces financial accounts, that one can be a little bit tricky too, because you need to find a way of recording what the actual assets and liabilities are. So when we started looking at this as a law firm, we found heaps of stuff in our deeds that fitted all of that, and they then had to work out a way to try and store it all. And I am picking that for clients who have professional trustees, they will be relying on the professional trustee to keep all those things in the wagon wheel. But it is worth having that discussion because you actually consciously will need to make a decision about who is going to hold what. You should find your trustee to make sure you have that, and then you need to be talking to your other trustees, if it involves a lawyer and accountant, and saying who's going to hold the rest of it. Because what will happen is that over the course of a year, there will be more documents that will fit those descriptions, and somebody's going to need to hold them. So, for example, if you, midway through the year, you purchase a new rental property in the trust, that's a core document, and one of the trustees is going to have to hold it. And like I say, if it's a professional trustee involved, they will want that agreement for sale and purchase. Probably not bad if it's the lawyer, because they probably acted on the conveyancing, but if it's the accountant, they'll be wanting to have it. You are required to hold those documents for the duration of your trusteeship, and they've got to be passed on when you're no longer a trustee to either back to the trustees or to the incoming trustees. So it seems like you've got to hold them for quite a while, and that whole process will be a decision for trustees to make, and needing really to be made within the first year, so by January 2022. Okay, on to the big kahuna. This is the one that's had the most press in terms of how this is going to play out. So this is disclosing information about the trust to the beneficiaries. And this principally will bring about the end of the days where you could not tell anybody about the trust. So you will not be, as trustees, allowed to decide to withhold all the trust information from all the beneficiaries. There is a presumption, instead, that you will make what is known basic trust information available to every beneficiary or their representative if they're a minor beneficiary, so say to the parents. users, basic trust information isn't terribly scary, but it will be a change for some trusts. So the basic trust information is that you are a beneficiary, so telling the person that they are a beneficiary, the name and contact details of the trustees, the appointment and removal and retirement of trustees as it happens. So if a trustee retires, then you're going to need to tell the beneficiaries that that has happened, and the rights of the beneficiary to request a copy of the terms of the trust. So that's the minimum level, if you like, or at least the minimum presumption. The definition of who a beneficiary is quite wide, so it's defined as a person who has received or who will or may receive a benefit under the trust, and includes discretionary beneficiaries. So the people who have already had benefit from the trust but who are no longer discretionary beneficiaries still fall in the definition of being a beneficiary for the purpose of the basic trust information. Now we're yet to see, we've been having a little debate in the office about how this will work if, say, somebody was a beneficiary 5 years ago of a trust and they got 100,000, but after that they were removed as a beneficiary. Whether that means now in 2021 you need to go back to that beneficiary and say, hey, there's a trust. And it seems counterintuitive, because the whole point of them being taken out as a beneficiary was not to give them, not to tell them anything or give them anything, but in theory that fits the definition of beneficiary, so we're not sure how that will play out. If you are going to fly in the face of the presumption that you have to give information to beneficiaries, you can give it a whirl, but you have to have, as trustees, considered a number of factors, and those factors are set out in the Act. There's a long list, but they are quite specific. So, for example, some of them are the nature of the interest in the trust that is held by that beneficiary and the likelihood of that beneficiary getting something out of the trust. Whether the information is personal or commercially confidential. The expectations of the settlor when the trust was created. Now, for a lot of trust deeds, there will be nothing in the trust deed that says what the expectation of the settlors were when the trust was created, because we just didn't really do that historically. I'm expecting that trust deeds that are formed now, there will be a statement in them which says, as settlors, we do not intend so-and-so to get information. We only intend ourselves and our children to get information. We do not intend the grandchildren or whoever. So that, if you can discern the expectations of the settlors, then that is one of the factors. The age and the circumstances of the beneficiary and the other beneficiaries. So arguably, your grandchildren who are above 20, 18, there will be a decision there for trustees about whether they should be given information in their own right. For children, grandchildren that are under that age, you're probably fine in terms of giving it to the parents, but for grandkids who are older, particularly, you know, the 23-year-olds, it's going to be a question of should you give them information or not. Relationships within the family and between the trustees and the beneficiary requesting information. So consideration, I suppose, of whether it may create a tension or a problem. The practicality of giving information where there's large numbers of beneficiaries. So a lot of trust deeds will say that as a discretionary beneficiary, charities or a number of charities or just a blanket charities clause, maybe you can argue that the practicality of giving information about the trust and its assets to charities when they aren't defined charities is impractical. Whether the information can be given in a redacted form and the practicality of imposing restrictions on the use of information. So if as trustees you decide that you're not giving information, then you're going to need to record your reasons for having done so against the factors outlined in the Act. Because if your decision is challenged by a beneficiary, you're going to need to be able to refer to your reasoning. And the judge will be quite interested in your reasoning as well. If you decide to give no basic information to any of the beneficiaries, then the Act says you have to, as trustees, apply to the court for directions as to whether your decision to withhold information is reasonable in the circumstances and whether there's an alternative means to hold trustees accountable. So that the thrust of this whole disclosure of information to beneficiaries is beneficiaries need to hold trustees to account, and the only way they can do that is by having information about the trust and the trust fund. And if trustees aren't going to give them that information, then there needs to be a way that this can be done in some form. There is provision in the Act for trustees to request that a beneficiary pays reasonable costs of giving information. So you might, as a trustee, take that tact. Yes, we'll give you information, but we need X amount of dollars to do so. And that will be a big change. So as trustees, it's time to have that chat about who's going to get the information. How are they going to get it? Are we going to go beyond the basic trust information? Are we actually going to say, well, we'll give them a copy of the trust deed and we'll give them the last set of financial accounts? You might, as trustees, decide to do that. You might decide coming on the front foot is better than coming on the back foot in terms of having trustees then ask you for more information, because my suspicion is that if you are a beneficiary with a bit of an axe to grind, the moment that the trustees come to you and say you could request a copy of the terms of the trust and more information, that beneficiary is going to go, righto, tell me what you know, because that tends to be human nature. So whether you want to front foot that as trustees or wait and see what happens is a decision to be made. But that how you're going to do that disclosure is important. We are taking the cue from the legislation that you probably need to have done some disclosure by 31 January 2022. Probably got a year. That's not written directly into the legislation, but there are other provisions which talk about yearly. So we think that will be the outcome of that one. Okay, so trustees' duties, holding core documents, and information to beneficiaries. Those are our three big changes. Okay, so I talked a little bit before about the importance of wills and letters of wishes. And I did touch on this before, but it's important and it happens frequently. So many people get very confused between what their will does and what will happen to their trust when they die. A will only deals with the assets that you own in your sole name when you die. Sole name, not joint name, sole name. And this is really important for all of you who have kids that have, or yourselves that have KiwiSavers. KiwiSaver is an asset in your sole name. If you do not have a will, you will have a problem. And we are seeing a lot more applications for letters of administration rather than probate, because most people's KiwiSaver now has reached the level where it's above 15,000, and if they don't have a will, we've got an asset and no one to administer it or give it to. And it is a pain in the bum. So if you have KiwiSaver, or your children have KiwiSaver and they're going, I don't own anything, yes they do, yes they need a will. So to be very blunt with you, you dying will have very little effect on your trust. It's a bit sad, isn't it? Other than that a new trustee probably is going to need to go into your place. So what your will may do in relation to your trust is to talk about who you would like the power of appointment of trustees to be held by when you're not here. So some trust deeds will say that as the person who set up the trust, you hold the power to hire and fire trustees, and you can transfer that power to somebody else when you die via your will. So you might see a clause in there that says, I appoint Bob Jones to hold the power of appointment that I have of trustees of the Smith Family Trust, and I ask him to appoint himself as a trustee when I'm dead, basically. You might transfer that power of appointment to your children, and you may or may not say who you'd like to be a trustee. So there's a distinction between holding the power of appointment and who actually becomes the trustee, because it might not be the same person. I might hold the power to appoint trustees, but I might actually appoint someone else. Lots of you, though, will probably want it to be the survivor of you and then your children. Some trust deeds don't allow the transfer of the power of appointment of trustees. They'll just say that it's the executors of your will. So if you don't have people that you think would be good at controlling your trust when you're not here as your executors in your will, then that might turn into a problem. So you should check your trust deed, make sure you know who holds the power of appointment, make sure you know who's going to hold it when you're dead, and if it's not somebody you like, change it. The trust AGM is a really good time to pull out your will as well. So you should be looking at what you own at that point in time and who's going to get it. And often we do have people who have not looked at their will for 20 years. 20 years is too long, okay? Needs to be about 3 to 5 on average, we say, because there's lots of stuff that happens that your will needs to reflect. So there might be a baby in the family, or you might have young children, and really your will should talk about who will be the testamentary guardians of the kids. We often find wills where one of the executor in the will has died. There is no point having a will with a dead executor. It doesn't make life any better. The other curly problem that people often fall foul of is that marriage revokes a will. So if you were a de facto couple and you subsequently married, your previous will no longer be valid and you're going to need a new one. And we have had that happen where people did not realise that by getting married their will went goodbye. The other thing people don't realise is that separation from a partner or your spouse does not automatically revoke your will. And we have had that awful situation too, where people have separated thinking, and got a new de facto partner, thinking life is fine and the new de facto partner is going to get everything, and it just doesn't work like that, because you're still married to that other person and the law gives preference to that person. So separating in and of itself is not enough. There needs to be a court separation order, and they are exceedingly rare these days. So if you have separated, one of the first things you need to think about is not who's getting the crockery, but who you want in your new will, and go and do a new will. You also need to think about your life insurance policies, because the amount of times that I've seen people separate, they don't deal with their life insurance, and the life insurance isn't owned by the person they don't love so much anymore, and the money ends up with the person they don't love so much anymore, and that's a bit of a kicker. So that one's not so good. Okay, I said before, I think I did anyway, said about letters of wishes. So letters of wishes are about the trust. They're also known as memorandum of guidance, and I would hope that when you formed your trust, a lawyer or an accountant said you need a letter of wishes or a memorandum of guidance. So they are a document that sets out how you want the trust to be run, and what your thoughts were for forming the trust, and what you want to have happen with the trust when you die. So in some ways it's a little bit like a will for the trust. So you might you might set out in the letter of wishes what your objectives were in forming the trust. You might talk about how you see the trust fund being distributed at the end of the day. The thing to remember with letters of wishes is that they are not binding. So you cannot bind the trustees to follow what you've put in the document. And there's a rule that says that you can't fetter the exercise of a trustee's discretion in the future, which is why letters of wishes and memorandums of guidance aren't binding. You might talk about how you envisage grandchildren being provided for. Perhaps you envisage that they would get money to buy a business or a first home or to fund education. You might say that when the trust fund is wound up, you do want all the children to be treated equally, so if any of them have had money along the way, it should all be squared up at the end. Any good estate plan, in addition to a will, should have some enduring powers of attorney. The will is for when you're dead. The enduring powers of attorney are for when you're alive, but funny in the head. Okay? You need to appoint someone who can act for you on your behalf. And there's two types. There's one for property, so your bank accounts and the land that you own, and one for your personal care and welfare. So that might be things like medical treatment or going into hospital or aged care. Contrary to very popular belief, being married does not automatically mean your spouse is your attorney. Shock horror, I know. If you want your spouse to be your attorney, you actually need to do the document and nominate them to be your attorney. If you don't have an enduring power of attorney and you become mentally incapable, then somebody has to apply to the court to become your property manager or your welfare guardian. These things are costly and they are time consuming, and they are particularly galling if there is a house which needs to be sold to pay for the care of the person who's become mentally incapable. It is not fast and it's not cheap. So having enduring powers of attorney, which to be perfectly honest are relatively cheap as compared to the cost of the court action, is like having insurance really. So if you don't have enduring powers of attorney, get them, get a will, and if you've got a trust, letter of wishes is the other part that needs to fit in with that. In addition to enduring powers of attorney, there's such a thing as a trust power of attorney. So that's somebody to act for you in your capacity as a trustee. This one is a little bit limited because it's only going to apply in circumstances where you are temporarily physically incapacitated or you're not in New Zealand, so you're travelling. None of us will be doing that anytime soon, so that one probably doesn't apply, but it can't be used in the event that you become mentally incapable. So in that instance, you've actually got to come out and be removed as a trustee. But for some people, having that trust power of attorney as well, so somebody else can do things for them as trustees, is important. All in all, if your trust and your personal affairs are reviewed regularly, then the likelihood of getting expensive accountant or lawyer's bills is smaller. Prevention is better than cure, and you will be able to be proactive instead of reactive. In my experience, reactive is costly, time-consuming, and stressful. Okay, so you've got to the end of this, and you're all now supremely convinced that your trust, you don't need it anymore. So your useful purpose is, the purpose of the trust is dried up, so you're no longer in business and the creditor protection thing's lost its significance, or you did lo and behold set it up for a residential care subsidy and you've decided that that's not going to really pan out either. I do have a small caveat with the residential care subsidy. For a lot of people who set up trusts early on and who gifted assets when they were worth very small sums of money now, so when houses were worth 80 or 100 grand, keeping the trust may actually work out for you, simply because that you'll be able to preserve the capital in the trust. You probably won't be able to preserve the income, but you'll probably be able to preserve the capital. So be careful if you are planning on getting rid of it because of the residential care thing, that you do just check out that there isn't a way that you will become eligible. If you have very little assets outside of the trust, everything is in the trust and it went in relatively early for low value, possibly the trust will be good to keep. So before you decide to wind up the trust, you need to have a look at the trust deed. So some trust deeds say that you can bring the final distribution date forward, and others have very particular provisions about who has to receive the trust fund when it ends, and there are ways and means to do this. So for some trusts it'll be a matter of using the discretionary capital distribution clauses and then basically raiding the trust fund, if you like, so that then you bring the end date forward and you go, oh look, there's nothing in the trust, end of. For others it will mean let's actually bring the end date forward and let's give out the assets to the final beneficiaries specified in the trust deed. So horses for courses, and it takes a bit of looking as to what's the best way to roll there. If you are going to take the trust fund back as mum and dad and the final beneficiaries are your children, prudent practice as a trustee would be to get your children to sign off on that or to consent to that as beneficiaries. Because what you have done is effectively raided the trust fund for yourselves, and them as final beneficiaries are going to not obviously receive via the trust. That's not to say they won't receive under your will, but they're not going to receive from the trust. So if you wanted to make sure that as a trustee this wasn't going to come back and bite you in the butt in terms of winding up the trust, that would be the most prudent way to do it. To actually have the children sign off the document, which will likely be a deed of distribution, in terms of consenting as final beneficiaries to giving the trust fund back to the two of you. You need to make sure you've got an accurate and up-to-date set of financials for the trust if you're going to wind it up. You need to make sure there's no debts owed by or to the trust, and that there's no gifting balances that haven't been dealt to. If, for example, a trust is owed a debt by a company, that, you know, your business company or whatever, then you need to make sure that that debt is assigned so that it becomes owed to you personally rather than the trust. Because when you wind up the trust, there's no sense having debts owed to the trust. It won't be there anymore. You must always discuss the winding up of the trust with the trust's accountant. Accountants will be very happy to hear me say that, but it is very true. There may be lots of curly things like depreciation recovered if you've got rental properties, negation of losses, loss of continuity, or GST consequences because you're stopping a taxable activity for GST purposes. There could be bright line test problems as well. So if you have only recently brought a property in the trust and you are now going to take that property out and distribute it back to you, any capital gain on that property from when it was purchased by the trust to when it gets distributed back to you will be liable for income tax. And if you are an unfortunate trustee who has distributed all the money and not accounted for that liability, you'll be stumping up out of your own pocket. So bright line, it is now 5 years, it is not 2 years. So there are lots of people where properties have been bought relatively recently. The 5 years hasn't gone by and they go to actually distribute out and they cause themselves a problem. The IRD is going to need to be informed of the wind up of the trust, and you're going to need to file a final tax return. In terms of costs to wind up a trust, they can vary quite a lot because it depends really on the assets in the trust. If there are mortgages on titles, then the bank is going to have to be involved. So not only will the title need to be changed, as in registered back into whoever's receiving the property, but the bank will need to know about that and the bank will need to consent. And that probably will unleash a slew of documents from the bank because they'll want new loan agreements and all the rest of it. There may be cause to do something called a resettlement rather than a wind-up of the trust. So a resettlement is where part of the trust fund is settled on, or all of the trust fund is settled onto a new trust. And some of the beneficiaries will be the same in the old trust as well as the new trust. So that might be an option. That's one to discuss with the lawyer. You often see it in relationship property situations where couples have split up and there's assets in the trust and one partner's or spouse is taking one house and one spouse is taking the other house, or one's going to carry on with the trust. You may resettle that particular house out of the trust fund onto a new trust for the spouse departing, and leave the other house in the existing trust with the spouse that's going to carry on with that trust. So you do see that sometimes, and that might still work in this situation too. You might just be going, well, actually I don't mind having the trust, but I don't really want so-and-so as a trustee anymore. So if you think that perhaps they're going to be difficult to get hold of, or all this disclosure stuff, and not disclosure, keeping information is going to be a problem, then you might like to check out how you can remove trustees and whether that's a possibility. Be aware that some trust deeds do have a minimum number of trustees, and some trust deeds have a requirement that at least one trustee must not be a beneficiary. And if you try to take out or don't meet those requirements, you'll run foul of your terms of your trust deed, which is never a great place to be. What you also might look at to try and fix any problems, say with the duties, is a variation of the trust deed. So a lot of trust deeds will have a variation or a modification clause. It will say you can vary the terms of this trust deed provided blah blah, and a lot of them say provided it's for administrative purposes and it doesn't interfere with the beneficiaries in terms of their entitlement. Some of them have very narrow variation clauses, some of them have exceptionally wide variation clauses, and if you're going to try and rectify your trust, you need to have a look at how those work. If having looked at the residential care thing and you decide it's still a good thing to wind up your trust, there is something called a trust reversal, which is permitted by the ministry. It's pretty limited as to when it can apply. It has to be the same house as what was originally in the trust, and for a lot of trusts that doesn't work, but that is there. If you go ahead and you wind up your trust, then you absolutely must revisit your will, simply because a lot of people with trusts leave stuff in their will to the trust. If you don't have a trust anymore, that's a bit of a problem. So you need to have a look at your will and see how that pans out. If it mentions your trust, then you need to give your estate to someone else because the trust isn't going to be there anymore. Okay. Right, so wrapping up. Trusts are still relevant if they're formed for the right reasons. And when I say the right reasons, that's because you can explain what the risk is that you're trying to protect from. If you are a trustee, you must know your duties. You must know what your mandatory duties are, what your default duties are, and you must act accordingly. If you don't have good administrative processes now for your trust, it is time to find some, because that will be the difference between a trust that's well run and compliant with the law and one that isn't. And if it isn't compliant and well run, you run the risk that the whole trust is swept aside and all that protection that you worked for is not there anymore. The best way to make sure your trust is working is to have a regular warrant of fitness, is to have regular AGMs, yearly AGMs, and to look at your personal stuff alongside that. So your will, your EPAs, and your letter of wishes. So look at everything as a combined picture. If you come away thinking your trust is not there for is not relevant and is not there for any reason anymore, then you must talk to your lawyer and your accountant before you wind up a trust. There are too many pitfalls just to be deciding you're going to barrel ahead of that without looking into it. You might end up with a really large bill, and if you've taken out all the assets of the trust and there's no cash left, it's going to be exceedingly hard to meet that bill. So you must get legal and accounting advice before you wind up the trust.